Good evening. We're going to talk about the U.S. Constitution this evening. But to be more specific, we're going to talk about the First Amendment. The First Amendment was part of what was known as the Bill of Rights. The Bill of Rights came into being at the insistence of the Anti-Federalists. Before they would approve or ratify the U.S. Constitution, they wanted certain assurances. The U.S. Constitution gave us a form of government without going into depth about the rules and the laws that each individual citizen would be allowed to have. They felt like that the Constitution relied too much on the states to make all the laws and guarantee all the freedoms, which all of them had just recently fought very hard for to give. So when writing these, they came up with 10 amendments. The first one is one we're going to talk about tonight. In it, it said that there would not be an establishment of religion by the government of the United States. And then it guaranteed 5 freedoms. Often when we teach these in civics classes in middle schools and high schools, we refer to it as RAPS. R-A-P-P-S. It is the freedom of religion, the freedom of assembly, the freedom of petition, the freedom of the press, and last, freedom of speech. Although they don't come in that order as it's written in the Constitution, it's the easiest way for most students to remember these. I wanted to look at, to help us understand, just instead of just saying that there are these freedoms, to look at particular court cases that help define each one of these types of freedoms that we now have. The first one, freedom of religion, is one of the most obvious in that it's the Everson versus the Board of Education of the Township of Ewing in 1947. It is in this court case that they delve into the ideas of what Thomas Jefferson meant when he's talking about the separation of church and state. Justice Black interprets this as a high wall that should separate the church from the state. In this, Everson was sending his child to school, parochial school. He wanted the same type of transportation money allowed to him that he had to afford to send his child there that all public schools got. In this, he lost the court case because Justice Black said that there should be a wall that separates the church from state. Although in doing so, he ignored the historical precedents set in this because he quoted Jefferson in his Bill number 82 on religious freedoms in Virginia state, while ignoring Bills 83, 84, and 85, and 86, which showed that their relationship should be more of a flexible relationship instead of there being a high wall that separated the two. I would look at the court case of NAACP versus Patterson in 1958. The NAACP versus Patterson in 1958. The state of Alabama tried to get the NAACP to reveal all the names and addresses of all of its members. The Supreme Court came down on the side of NAACP and said that they do not have the right to have this. This was during the time of the civil rights acts that were going on, and the NAACP was very protective of its members. They were afraid of the state handing these out to individuals who might then threaten their memberships and keep them from trying to exert their civil rights. The third one comes down to freedom of the petition. That is a court case we're going to look at is from Meyer versus Grant. It's a much more recent one. It was in 1988. Colorado is one of the few states that has the right to, when enough people have signed, to get a measure for a law put in for a vote on the state level. What they were noticing that there were certain groups who wanted the law, they would actually, since this was an odious task, hire people to go out and get people to sign petitions. The state of Colorado said that under their state law that this was a felony, that you could not have that as a job. The Supreme Court came down against the state of Colorado and said that while this task, often only somebody who was young and full of vigor, has actually said that had the ability to do this, that it is almost like a job, and so they should be able to be paid for it. And it was not against the law. It would be against a person's right of petition to do so. The next one is the freedom of press. And New York Times versus the United States in 1971, they released a copy of the Pentagon Papers, which Richard Nixon said this was considered classified documents, that the release of this information would interfere with foreign policy and actually prolong the war. Yet the Supreme Court came down that the New York Times right to actually publicize this was protected under the First Amendment. And last but not least, we have the freedom of speech. An individual named Schneck in the beginning of World War I began to send out letters to those people who received a draft notice in the mail, saying that they should not come to be registered for their service in the military, as this would go against the principles of the United States. We should not be involved in this war, and he wanted them to not participate in it. The United States government took him to court, and he was shown to be interfering with a real incredible threat to the United States. Justice Holmes equated it to someone walking into a theater and yelling fire when there was in fact no fire, and actually causing more damage of it. His quote on the end of it was that the question is whether the words are used in circumstances are such as a nature as to create a clear and present danger that they will bring about substantive evils that Congress has the right to prevent. It's a question of proximity and degree, showing us that just because we can say something doesn't mean that we should say something, that sometimes the words that we might use are going to harm, and that we do have boundaries on these things. So as we can see, all of the parts of the First Amendment have been, to some degree, have come under great judicial review and have used to help us ensure that we have these rights today. Thank you.